Hey everybody, I'm Valerie 𝗬𝗍𝗘 of 𝗬𝗍𝗘 Law, where we provide peace of mind to families through estate planning, elder law, and probate matters. Today we're going to talk about how you can protect your minor children through your estate plan. Before we get there, however, if you have any estate planning or probate questions, you can reach out to us for a free conversation at 𝗫𝗺planningattorney.com. That's 𝗫𝗺planningattorney.com. Now, this is very prevalent in our minds today as we're getting ramped up for our first program for the young families in our community, and it's entitled 𝗫𝗍𝗘. You can check that out at 𝗫𝗺plan.com if you're interested. But minors are a key, if we have them, to our plan, and we want to make sure everything we're doing does protect them in some way. And every piece of your estate plan does do that exactly. We want to make sure we're protecting ourselves for incapacity through our power of attorney and health documents by designating the right individuals to cover those choices if, God forbid, something happens to us, such as a stroke or something where we're still around but just can't make those choices. Certainly, if we have minor children and find ourselves in that circumstance, it's imperative to have those choices reflected and implemented into a document. It will relieve some of the stress for the family overall, and of course the stress that will residual down to your children. In addition, it's important that your last will and testament designates guardians for your children. If you and the other parent are no longer around, we want to make sure we have someone there to protect them and take care of them in their that time of need. Take care of them as a person, to make choices for them in their individual day and what the choices are that need to take place relative to health, relative to schooling, extracurricular activities, and all the things that are important to a young person. In addition, your last will and testament, and or maybe in certain circumstances a trust, will designate the individuals who have the responsibility to take care of the finances for your children. If you have a life insurance policy or retirement account, you don't want them going specifically to your child, who then, if they're a minor, would receive it at age 18 outright. That time in their life is pretty impressionable, and they're going through some maybe choices that wouldn't be necessarily the best at age 18 if they have a ton of cash sitting in their lap, right? And so we want to make sure we have guidance incorporated into our estate plan so that they can help them make the right choices for the use of those funds as they reach adulthood. And so that trustee or the personal representative under your will would be that guide. Keep in mind that the personal representative or trustee who's making financial choices may be one and the same as the guardian for them as a person. However, you could also choose to have separate responsible parties for checks and balances, should you choose. It's our guidance, though, if you're going to have two parties serving in those separate roles, that they know one another and they can collaborate well with one another. It's important for the child's security, safety, and as seamless transition as possible, despite it being a pretty tumultuous time, as you could imagine, should that ever occur. We hope this information is helpful, and as a reminder, if you have any estate planning or probate questions, you can reach out to us for a free conversation at 𝗫𝗺planningattorney.com. That's 𝗫𝗺planningattorney.com. Thank you so much for listening, and if you think anyone may find this information useful or you liked it yourself, please share, like, and subscribe where appropriate so nobody misses out. And again, I'm Valerie 𝗬𝗍𝗘 of 𝗬𝗍𝗘 Law, where we provide peace of mind to families through estate planning, elder law, and probate matters. Take care.